Hey, welcome everybody. Thank you so much for joining us tonight to hear about this important topic. Tonight, I'm super excited to have Melissa Black with us. She's the Community Engagement and Disability Specialist with UNC Cares, and she is going to talk to us about unpacking the updated law, guardianship, and less restrictive alternatives. A couple things before we get started. I would ask that we hope that you guys have tons of questions because that is why we are all here, and we are saving a good amount of time at the end for questions. So Melissa has about an hour of content, and then we'll have about 30 minutes, give or take, at the end for questions. Please put all of your questions as you think of them in the Q&A. So you should see a little box on that little toolbar that says Q&A. You have a chat, you have a Q&A, and maybe some other icons down there. I probably see different ones than you do, but that's because, the chat, we can make comments and the questions can go in the Q&A. That way we make sure that at the end that we see everybody's question and that everybody's question has an opportunity to be asked and answered. Also, I'm recording tonight's webinar and I will send a follow-up email usually in about 2 to 3 days that will include a link to the recording. It will include the slides, and it will also include any other links to any other resources that come up during the presentation or that Melissa would like to add to the follow-up information. Also, this video will be uploaded to ECAC's YouTube channel probably before the email goes out. So if you really wanted to see it sooner before the email goes out, or if you would like to share it with somebody that you can go to ECAC.org YouTube. I will put it in the chat and you can view it there, along with, we have a ton of other excellent recorded webinars that are on there as well. So if you've never checked out our YouTube channel, I highly suggest you go check it out. And again, that's ECAC.org. If you just type in ECAC, you're going to end up at a hockey team's YouTube channel. So please, ECAC.org. So with that, I will turn it over to you, Melissa.
Okay, great. Thank you. Good evening, everyone. Thanks so much for spending your time with me tonight. I do appreciate it. Again, as Christy shared, I'm Melissa Black, and I'm the Community Engagement Disability Specialist at UNC Cares. And today we're going to talk about guardianship, and particularly focusing on the use of less restrictive alternatives. And so just a quick agenda review. Again, we'll talk about adult guardianship. We'll have a quick introduction to the three main sections of the updated law, and then we'll spend some time talking about those less restrictive alternatives, which is one of the main updated sections of the new law. But before I start, I just want to introduce you to the rest of our team. So this is CARES at the UNC School of Social Work. And CARES is a state and national resource center that improves the lives of older adults and people with disability through collaboration, education, evaluation, and advocacy. And then before we start, I'd really like to share Tyler's story. He is a gentleman that was placed under guardianship by the LMEMCO and was able to have his rights restored, and just kind of sharing that process. So just give me a moment to pivot to that video.
My name is Tyler Freeman, and I currently live in Charlotte, North Carolina, but I am a native of Asheville, North Carolina. I am 27 years old, about to be 28. I have cerebral palsy. I was born at 28 weeks, 3 pounds, 7 ounces. My parents were very supportive, especially my mom. She taught me how to be a fighter. That's where I got my fighting instinct. Oh, here's a cute one of me and my mom. That was at my aunt's wedding, so I would have probably have been 7. Me and my mother have been through a lot together, but I wouldn't change it for the world. My mother's my everything. Here's a picture of me and my dad. I think this was Father's Day. He was giving me a kiss. Looking back on the pictures from my mother and father, it makes me feel how blessed I was as a child. And I'm so thankful for both of them. Well, in 2014, the LME petitioned for guardianship. There was one evaluation that I will never forget. An evaluator who did a psychological eval, who only saw me for 15 minutes, but yet determined that I needed a legal guardian by that experience. The label of incompetency is huge on a person with disabilities, because we already have enough labels. Early 2021, it got transitioned to the Arc of North Carolina. Those people were amazing. They supported me in getting my rights restored, and they believed in me. They wanted me to be able to make the decisions instead of the guardian, and that's the way it should be. When it was Restoration Day, which was January 24th, a day I will never forget, Johanna Finkelstein, who is the Asheville assistant clerk, said, "I never thought I would be able to enter this verdict, but after 9 years, your rights are restored." And I literally just about cried. It was amazing. Amazing to feel the power again. And I think that's huge, because you feel like when you have a guardian, you kind of lost your voice. If I would have known my rights as a person that was under guardianship, I would have petitioned it long ago. If I knew that I could ask for a trial by jury or anything like that, I would have done it years ago. It's really about me feeling the confidence again. Some of the decisions that I make on my own are, where do I want to live? What do I want to do? Do I want to have these services? Or do I want to change up my services? What works for me and what doesn't work for me? Just because I have a physical disability doesn't mean I have to not be able to make my own decisions. And that's what I think people don't understand. My hopes and my dreams are to be independent as possible, to work an everyday job, to go out in the community, be a 28-year-old, and just be able to live life to the fullest, because we're never guaranteed a tomorrow. Whether you have an intellectual disability or a mental health disability, that doesn't change who you are. That doesn't define you as a person.
That is what it's all about. Fighting for people's rights, and making a difference. I know what I want in my life. Nobody else knows my life but me. I also want to advocate for those people that don't have a voice, because who knows how they're being treated. And that today is my mission. My mission is to help other people with disabilities because we all deserve a voice. You all deserve a voice. And that is my mission and my goal for myself and others.
Okay. Um, so yeah, that video really just kind of underscores the magnitude of pursuing guardianship. And while I appreciate everyone's situation is unique and different. Guardianship is appropriate for some, but for others, there are other options and other ways to maybe kind of think about guardianship. And we'll kind of go through those different options. But just really kind of underscores just, what a big decision that is for you and your family and for your child when you are pursuing guardianship. But before diving into the subject and practice of guardianship, it's critical to recognize that a continuum of support exists for adults with disabilities of all ages. So on one hand, there is full autonomy, and let's really just think about it like no one really is fully autonomous when you think about it. Um, I know that I need help making decisions, whether they're small or big. I don't make decisions in a vacuum. I consult with family, friends, my spouse, my kids, even they get a say sometimes on the decisions I make. So we all are, really kind of leaning into this idea of, supported decision making. And so that's considered to be a less restrictive alternative. And most of us use, these types of less restrictive alternatives without even thinking about it. And so when we use supported decision making and other less restrictive alternatives, we continue to make our own choices and turn to other people and other resources for help. And then finally, as a last resort, guardianship may be used when an individual needs a substitute decision maker. So autonomy means that a person is able to make their own choices and decisions about their life. It's when they have the freedom to do the things for themselves and take responsibility for what they decide. And then self-determination refers to the ability and the opportunity for individuals to make their own choices, control their own lives, and pursue their goals based on their preferences, values, and aspirations. It's a fundamental concept rooted in personal autonomy, empowerment, and the belief that everyone has the right to shape their own future, even if it's with help and support. And so studies have shown that when older adults and people with disabilities are more self-determined, that means when they have the ability to make their own choices, they have better lives. Several studies have shown that with greater self-determination, people are more likely to work, live more independently, and be well-adjusted, healthier, safer, and better able to recognize and resist abuse. But sometimes people are unable to make decisions or refuse to make decisions, putting their health or safety at risk. For example, a person may be in a coma or show significant cognitive impairments. They may be experiencing abuse, neglect, and exploitation, including self-neglect, or they may have decompensated without mental health treatment. Or even with support, a person may be unable to understand or communicate. And in these situations, guardianship may be necessary. So what is guardianship? Guardianship is a legal relationship. It gives the court gives a person the authority to make decisions in place of another person. The vast majority of guardianships give the guardian the power to make all decisions. And it's really important to understand that guardianship is not case management. It's not a guarantee of good health or safety. It's not entirely effective for preventing all bad decisions or risky behaviors. And it's not a guarantee that somebody won't be victimized. Um, in in the new guardianship law, it's really underscored that guardianship should be a last resort. And so written in the updated law, it is written as follows, that guardianship should always be considered a last resort for adults. and should only be imposed after less restrictive alternatives have been considered and found to be insufficient to meet the adult's needs. So, and then even if guardianship is determined to be necessary, as a last resort, there is still an expectation the adult subject to guardianship be included in decision making whenever possible. So, General Statute 35A, which is our guardianship law, states that guardianship should seek to preserve for the incompetent person the opportunity to exercise those rights that are within his comprehension and judgment, allowing for the possibility of error to the same degree as allowed to persons who are not incompetent, and to the maximum extent of his capabilities, an incompetent person should be permitted to participate as fully as possible in all decisions that will affect him. So, in other words, while clearly the most restrictive of all decision-making approaches, it's still possible and indeed part of North Carolina's law to include and honor an individual's choices about their life while subject to guardianship. And I do want to make a quick note about the language in the statute. You can see that the statute continues to use outdated terms like incompetent and ward. And while North Carolina courts still use this language, there's a growing shift both statewide and nationally towards more respectful and person-centered terminology. Current best practice recommends referring to an adult's capacity or just simply stating that the adult is in need of guardianship. So today we'll use adult in need of guardianship instead of incompetent adult, and adult subject to guardianship or person under guardianship instead of ward. However, when we are quoting directly from the statute, we will use the terms that are in the statute. So built into the updated guardianship law is this idea of dignity of risk. And dignity of risk focuses on the right of individuals to make informed choices and take reasonable risks in order to learn, grow, and have a better quality of life, even if those choices involve potential setbacks or challenges. It recognizes that taking risks is essential for self-determination, personal growth, and the development of new skills and experiences. Dignity of risk is the idea of allowing people the freedom to take risks, even small ones, to create new opportunities and experiences. However, we acknowledge that the word risk can sometimes sound alarming or be associated with danger, but it just simply means giving individuals the chance to make choices and explore new possibilities. Dignity of experience emphasizes the importance of providing meaningful activities that improve people's lives and well-being. It recognizes that individuals with disabilities often miss out on experiences that are common for others, and that these experiences are essential for personal growth, development, and a sense of belonging. The ideas of autonomy, self-determination, dignity of risk, and dignity of experience, all that we've covered so far, are so important that they're all included in North Carolina's current guardianship law and also included in the National Guardianship Association Standards of Practice. So Standard 9 of the National Guardianship Association Standard of Practice focuses on self-determination. Guardians are expected to support the person in using their rights and making their own choices whenever possible. They should encourage independence and self-reliance and involve the person in decisions about their life, including personal and financial matters. Guardians should also help develop a plan based on the person's goals, needs, and strengths. Whenever possible, the person should lead this planning process, and if they can't, the guardian must ensure that the person's involved in every step. Standard 7 of the National Guardianship Association's Standards of Practice emphasizes decision-making. And so in this Standard 7, the guardian should focus on the person's goals, needs, and preferences when making decisions. Guardians must first ask the person what they want and support them in expressing their wishes. If the person cannot express their preferences, even with help, the guardian should ask others who know the person well. And then only as a last resort should the guardian make a decision based on what they believe is in the person's best interest. So as a guardian, they are really kind of charged with substituted judgment, really thinking, kind of knowing that person's preferences, knowing their needs, knowing their likes and dislikes, making those decisions in that way, in that capacity, and not necessarily making those decisions in what they think is the best interest. Additionally, the National Guardianship Association's ethical principles emphasize promoting the well-being, autonomy, and rights of individuals under guardianship. Guardians are expected to act with integrity, avoid conflicts of interest, and seek the least restrictive alternative in decision-making. These principles serve as a foundation for ethical and person-centered guardianship practice. And so we'll quickly review those ethical principles. So, the ethical principles from the National Guardianship Association states that a guardian, 1, treats the person with dignity. 2, involves the person to the greatest extent possible in all decision making. 3, selects the option that places the least restrictions on the person's freedoms and rights. 4, identifies and advocates for the person's goals, needs, and preferences. 5, maximizes the self-reliance and independence of the person. 6, keeps confidential the affairs of the person. 7, avoids conflicts of interest and self-dealing. 8, complies with all laws and court orders. 9, manages all financial matters carefully. And then the 10th one is respects the money and property being managed belong to the person. So here on this slide, we have the different types of guardians. So the first one is guardian of the person. And as guardian of the person, they have the authority to make decisions in most areas of an adult's personal life, exclusive of assets. This includes giving consent or approval to any medical services that they might receive, with some limitations regarding sterilization and end of life. Another type of guardian is guardian of the estate. And in this instance, they have the authority to manage the adult's assets, such as their bank accounts, brokerage accounts, vehicles, real estate, personal property, and any income, such as pensions, dividends, wages, benefits, or interest. The third type of guardian is the general guardian, and they have the powers and duties of both the guardian of the person and guardian of the state. So they are kind of guardian of everything. The fourth is interim guardian, and this is a limited duration version of any of the above, appointed by the court due to an emergency. Its termination date is always very clearly on the document when that guardianship will end. And finally, the last one is limited guardianship. And we actually consider this to be a less restrictive alternative. It's tailored to fit the individual in the areas in which assistance with decision making is needed. So it's not full guardianship. It's just this person might need guardianship over their bank account. They just need help with the bank account, and that's it. And they can make all other decisions for themselves around finances and their personal being. So now let's quickly kind of review the process for obtaining guardianship. So first, a petition is filed with the Clerk of Superior Court, alleging that a person is unable to manage their affairs and make important decisions, even with support from a less restrictive alternative to guardianship. In North Carolina, the person being considered for guardianship is called the respondent. The petition must include the respondent's correct information. A copy of the petition is sent to the respondent, as well as to the respondent's next of kin and other people known to have an interest in the proceeding. Then the sheriff delivers notice of their rights and of the hearing to the respondent. A guardian ad litem, which is an attorney the court appoints to represent the respondent and gather information for the clerk of court. The respondent may also hire an independent attorney as well. If there is an emergency, an interim hearing can be requested. A hearing is scheduled, and all interested parties are notified about the hearing. It's worth noting that there are 100 elected clerks of Superior Court with exclusive jurisdiction over guardianships in each of North Carolina 100 counties. So inevitably, there will be differences in how clerks interpret the statute and their guardianship proceedings and practices. So we just always want to kind of emphasize that there are 100 counties, 100 jurisdictions, and 100 clerks of courts, all doing it just a little bit differently, and that it's not uniformly done the same way across the state. So at the hearing, all parties are entitled to present evidence and question witnesses. The clerk of court will enter a decision regarding the respondent's need for guardianship. And if the clerk of court finds strong evidence that a guardian is needed, they will decide which type and appoint one. So who can be appointed guardians? First, the court looks for someone the person has asked for or has named in a legal document, such as a power of attorney. The next priority is to appoint a family member or friend known to the individual. And then, if no one is available or suitable, the court may appoint a corporation or a disinterested public agent, or in this case, in North Carolina, somebody from the Department of Social Services. Again, as I had mentioned before, in North Carolina, the laws about guardianship are mainly found in Chapter 35A of the North Carolina General Statutes. This chapter outlines the legal framework for establishing guardianship, defining the roles and responsibilities of guardians, and addressing various aspects of the guardianship process, including appointment, powers, duties, and termination. Session Law 2023-124 was passed on September 28, 2023. It made important changes to guardianship laws to help protect the rights and independence of people who are going through the guardianship process or have guardians. It also allows the clerk of courts to closely monitor the guardians and hold them accountable for their actions. And these changes apply to all guardianship cases filed on or after January 1st, 2024. So here is the opening paragraph to the new law. You'll notice that the sections relevant to guardianship reform were included together with other changes introduced by the North Carolina Bar Association through the legislative process in the spring of 2023. The revised sections are emphasized in red. So Session Law 2023-124 is an act to allow adult adoptees to be adopted by a former step-parent. But then kind of getting to it, it's to amend the general statutes to prevent the abuse or misuse of authority granted to an agent in a power of attorney and to promote the rights and independence of persons subject to guardianship process and to improve judicial oversight and accountability for the guardians of the person. There are three primary areas or sections within the guardianship law that were changed, including notice of rights, which will make sure people know their rights during the guardianship process, consideration for less restrictive alternatives to ensure other options are considered before deciding on guardianship, and then tools for monitoring and accountability to help clerks of courts efficiently oversee the guardianship cases in their county. In response to the new law, the North Carolina Administrative Office of Courts released new and revised incompetency and adult guardianship forms. This includes a new form, which is Notice of Rights of Respondents and Wards, which is AOC SP 197. And we'll go over that form in just a moment. A number of other forms were revised to reflect Session Law 2023-124 changes. This includes the petition, with the new requirements applicable to the consideration of less restrictive alternatives to guardianship. And we'll be covering the policy, procedures, and form changes one section at a time. So first, let's talk about the notice of rights and the guardian ad litem. The revised guardianship law now requires that those under consideration for guardianship, also known as the respondent, and those who have been determined to need a guardian, also known as a ward, be notified of their rights. The Notice of Rights is a double-sided form with the rights of the respondent on one side and the rights of the wards on the other. And here on the notice of rights for the respondent, you can see that they are being notified that they have a right to notice, that they have a right to hire an attorney, they have the right to gather evidence, they have the right to a hearing and to call witnesses. They have the right to a jury. They have a right to a closed hearing. They have the right to present evidence and testimony. They have the right to call witnesses and to question witnesses. They have the right to express wishes regarding their rights. They have the right to express who should serve as their guardian if one needs to be appointed. And then they have the right to appeal. For the person who's been adjudicated or placed under guardianship, their rights include the right to a qualified, reasonable guardian, the right to request transfer to another county, the right to request restoration of competency, the right to request a review or modification of their guardianship. They have the right to vote. They have the right to request a hearing and petition for procedure to permit sterilization. They have the ability to drive, and then they have some additional rights. They're kind of included further down in the statute. So let's take a deeper dive into the service of notice of rights. The service of notice of rights applies only to adult guardianships. This notice must be served along with the petition for adjudication and the initial notice of hearing. The recipients of the notice of rights include the respondent, the interested persons listed in the petition, and the guardian ad litem. It's important to note that if the notice of rights is not properly served, then the hearing cannot proceed. And we also like to kind of also make the note that, again, the notice of right and the notice of hearing and the petition are all served by the sheriff. And so we always kind of recommend that working with the sheriff's department, that when this packet is being delivered to the person, that, they're wearing plain clothes, because it can be scary when somebody in a uniform and in a sheriff's uniform is approaching you with a packet of paper. So we always kind of encourage folks to be mindful and thoughtful around that. The guardian ad litem also has an important duty to go over the notice of rights with the respondent or ward as soon as possible before any guardianship hearing. If the respondent or ward later asks to review the notice of rights again, the guardian ad litem must take the time to review those rights. Historically, before this updated law, sometimes the guardian ad litem would meet the person as they were walking into the courtroom. Now it's very clear, and the onus is put on the guardian ad litem that they meet with the person beforehand, that they spend the time, making sure that they understand that their notice of rights, that they do their due diligence in collecting information for the court. So making sure that, we are avoiding those instances where we're walking into the court together and quickly going over those rights. In addition to ensuring that the respondent and ward are aware of their rights, the guardian ad litem serves two additional purposes. So the first kind of charge of the guardian ad litem is that they are responsible for learning what the respondent or ward wants and sharing those wishes with the court, even if they don't match what's in the best interest for the person. And then the dual role, so they kind of have to wear two hats here. They still have to make a report to the court. So if the guardian ad litem believes that the respondent or ward's wishes are not in their best interest, they must still tell the court what they think is truly best, even if that goes against what the person wants. So in some cases, one could almost argue that it's almost a conflict of interest, and that there is some work being done with guardian ad litems, with kind of reviewing the current statute as it exists, like should we break this rule out? It seems, again, with that conflict of interest, that they're charged with representing what that person wants, but then they put the hat on and they say, but here's what we think and what we recommend. And if they don't correlate, then that can be a bit awkward. And then that's why we always say that the respondent and ward can choose their own lawyer if they don't want the guardian ad litem to speak for them in court. But again, the guardian ad litem must still meet with them and still report to the court what they believe is in the individual's best interest. So the second part of the updated guardianship law is just changes in judicial oversight and monitoring. So the next section provides the clerks of court with more tools for monitoring and accountability. Until now, the clerk of court was unable to file a motion in the cause, which is a legal term, to modify guardianship and always had to wait for a third party to make that request. The second part of the updated guardianship law is the North Carolina Bar Association added a piece to the bill giving courts more discretion in awarding attorney fees to incentivize actions in the best interest of the person alleged to need a guardian or modification or restoration. And this is really just to kind of, protect them against maybe parties that don't necessarily agree and just want to drag everything into court, excessively, not acting in the best interest of the respondent. Another change is that until now, the guardians of the person have never had to report a change in address. And then the fourth is, while public guardians, and so those are your DSS and corporate guardians, always have to provide a status report, the vast majority of guardians are often family members, and as guardians of the person, they've never had to report to the court after appointment. And we'll go into a little bit more details on all four of these in the next few slides. So the first tool we'll address is the motions in the cause on the clerk's own motion. This section now reads, any interested person or the clerk on the clerk's own motion may file a motion in the cause with the clerk in the county where a guardianship is docketed to request modification of the order appointing a guardian or guardians or consideration of any matter pertaining to the guardianship. And so this is a significant change because it means that the clerks don't have to wait for a third party to have a hearing. And the hearing doesn't have to be tied to an annual report. So let's say, for instance, that a change in address was not filed and the person moved 3 times and it was never reported. The clerk, and that might be alarming to the clerk, the clerk can then choose to file a motion in the cause to modify guardianship, to modify that guardianship appointment if they get wind of it. Now, in regards to attorney fees, the North Carolina Bar Association added another tool by limiting the fees attorneys can charge against the person's estate. And so through changes to 35A-1116 speaks, specifically to those attorney fee awards. The law gives courts more flexibility to order payment of attorney fees, encouraging actions that support the best interests of the person under guardianship or those requesting changes. Additionally, the petitioner will be responsible for paying attorney fees if it's determined that there was no reasonable grounds for bringing the proceeding. So note that this part of the statute is designed to hold all parties accountable and minimize adversarial behavior by attorneys if it's deemed to be unhelpful to the respondent. Attorneys need to be mindful that they shouldn't be antagonistic or adversarial. And any attorney, even those used by the Department of Social Services, can be penalized by attorney fees. So if it's a DSS attorney, they're not immune to these fees. And then finally, under the new law, guardians of the person are now required to notify the court if there's a change in address to the person under guardianship. Failure to comply with this requirement could be grounds for the guardian's removal, and this rule applies to both current and future guardianships. Now let's talk about annual reports. So initial and annual status reports are required for public guardians like DSS and corporate guardians, but the updated law now encourages all guardians to file status reports. Clerks now have the discretion to ask for these status reports when they have concerns about the well-being of the adult served by guardianship. And this is really speaking about the guardianship of the person. If there is any finances involved, then of course a report has to be filed every year with the clerk about those finances. And then here, this is just kind of how it's written. We don't need to go over that. So let's just take a moment and clarify what the clerks of court can and can't do. So they can order a status report, they can file a motion in the cause, or schedule a hearing based on another person's filing. This can then trigger the appointment of a guardian ad litem, who is an attorney, who will then hear, what the preferences and wishes are of that person, and then report to the court what they think is in the best interest of the individual. The clerk of court cannot, though, advocate for the individual. That is not their job. All right, so moving on to the next part of the updated guardianship law, and that's the less restrictive alternatives. So as I had said before, it's written in the general statute that guardianship should always be considered a last resort for adults. It should only happen after exploring and determining that less restrictive alternatives are unable to meet the adult's needs. And again, this was included in the Session Law 2023-124, which we've talked about. And so it was so important that they actually even defined less restrictive alternatives in the law. So, and in the law, it's defined as an arrangement enabling a respondent to manage his or her affairs or to make or communicate important decisions concerning his or her person, property, and family that restricts fewer rights of the respondent than would the adjudication of a competency and appointment of a guardian. This term includes, and I think this is really important that they even call out and name some of the less restrictive alternatives that we'll talk about later. This term includes supported decision making, appropriate and available technological assistance, appointment of a representative payee, an appointment of an agent by the respondent, such as a power of attorney or a healthcare power of attorney for finances. Additionally, the updated law changed the definition of a competency to include less restrictive alternatives. Before, a person was considered incompetent and needed a guardian if they lacked sufficient capacity to manage their own affairs or make important decisions. Now, the updated definition states that an individual is not considered lacking capacity if, with the help of less restrictive alternatives, they are able to manage their affairs and make decisions. So this means that if the less restrictive alternatives are working to help the person manage their affairs and make decisions, then the clerk must dismiss the petition for guardianship. And so here you can see the definition. An adult, emancipated minor or minor at least 17 and a half years old does not lack capacity if by means of a less restrictive alternative, he or she is able to sufficiently, one, manage his or her affairs, and two, communicate important decisions concerning his or her person, family, and property. Now, when somebody is completing the petition for adjudication of incompetence, an application for appointment of guardian or limited guardian, they now have to include a statement about which less restrictive alternatives they've tried, and then explain why those alternatives didn't work. This helps make sure that an individual placed under guardianship is placed under guardianship only when it's absolutely needed for the health and safety of the individual. And so here you can see where I've kind of, clipped the actual petition for adjudication for incompetency or for incompetence. And so you can see that question 6 is, I consider the following less restrictive alternatives prior to seeking adjudication of incompetence. And here you have to write in and kind of list the less restrictive alternatives that you've tried. And then in the next box, the less restrictive alternatives listed above are insufficient to meet the needs of the respondent because, and then you have to explain why they're insufficient. So you really have to kind of make your case of I tried X, Y, Z, and here are the reasons why they didn't work. And again, in the petition for adjudication, of incompetence. It even includes the definition of the less restrictive alternative on that form. So we really think that less restrictive alternatives, or LRAs, are tools that can help a person move from being found incompetent toward becoming competent again. So we at CARES, we kind of host the Rethinking Guardianship. You saw Tyler's story, and it's also on this website. And here you can see that we've got several resources available on our website. We've got information about guardianship. We have information about LRAs. We have an LRA hub. And we've got different stories. So it's a really great resource that I encourage everyone to look at. And we've developed 19 easy-to-use restrictive alternatives to guardianship. And we kind of have them organized in categories. So general, health, financial, and safety. Let's see. And then we've even taken all of those kind of fact sheets on the less restrictive alternatives, and we have this book that we've put together that's also downloadable and accessible on our website, and it's the Less Restrictive Alternatives Resource Guide. And so one of the less restrictive alternatives that we really like to talk about and feature is supported decision making. And so supported decision making is a way that we can empower people to make their own decisions and get the help they need to make those decisions. When people use supported decision making, they work with friends, family members, and professionals who they trust to help them. So we're going to look at this SAM's support and decision making plan video just to kind of see how that looks in action.
Supported decision-making is a less restrictive alternative that keeps you in charge of your choices with help from others. A supported decision-making plan is when you choose people you trust to assist you with understanding and making good choices, setting up a personal plan with details about your activities and resources needed, and communicating your choices and plan. This is Sam. Today, Sam is going to tell you how he created his plan for supported decision-making. Sam is 17 years old and lives with his mom, dad, and older brother, Bobby. He has Down syndrome. He also has some health issues. They include congenital heart disease that required multiple surgeries as a child, and obesity. He has a primary care doctor and sees a cardiologist for his heart. Sam has difficulty brushing his teeth, and sometimes his teeth hurt. He does not like going to the dentist. Sam does like spending time at home listening to music or watching TV. He likes going to church and walking the family dog. He also enjoys spending time with his brother and his brother's fiancée. They're getting married next year and are planning to move away to the city. Sam is not happy about that. He's enrolled in the Occupational Course of Study program at his high school. He would like to get a job when he graduates. He would also like to get a credit card and a girlfriend. Sam's family worries about what will happen when Sam finishes high school. How will his daily routine change? What kind of job could he get? Will they need to file for guardianship when he turns 18? Sam's parents are getting older. They worry about what will happen to him after they're gone. They worry about Sam's health. They worry about Sam dating and how he will get along in the world. They worry that he could be taken advantage of. Recently, Sam and his family began learning about supported decision-making. They learned that Sam could have people he trusts help him with things such as understanding the choices he needs to make so he can make good ones, giving him information in a way he can understand, talking about the good things and bad things that could happen if he makes one decision or another, and helping him tell other people about his decisions. Sam began by deciding what types of decisions and other things he wanted help with. He said, "I want help making appointments with my regular doctor and my heart doctor. I want to keep track of my health information because I have lots of records, and sometimes I need to be reminded to take my medications. Also, knowing what to do if I have a health emergency, knowing what will change when I turn 18, and knowing how to get to a doctor's appointment when I'm not living at home with my parents. And I want to learn more about dating girls. Next, Sam talked with his family about being his supporters. He asked his mom to be his main support person, but he wants his dad and brother to know what's going on and help him with some things. He wants his doctor to help him be healthy and stay out of the hospital. And he wants his brother to help him learn about dating and sex. Sam and his mom used the Rethinking Guardianship NC website, www.rethinkingguardianshipnc.org. There he learned about several tools, sometimes called less restrictive alternatives, or LRAs, that can help him and his support people make decisions and carry out activities in his life. The state of North Carolina does not have an official supported decision-making format. Some people simply make an informal agreement with their supporters, and other people create a formal written plan that everyone signs. Sam and his family decided together that they would write down Sam's plan and share copies with his support people that they don't need to sign. Sam made a list on the computer of the decisions and other things he wants help with. He wrote which supporters could help with what and the resources and other tools they could use. For example, he asked his mom to help him with making appointments, keeping track of his health information, and remembering to take his medication. He asked his dad to teach him how to dial 911 if he's having a health emergency and to help him learn how to take the bus to his doctor's appointments. He also asked his dad to help him with money so he could someday get a credit card. He asked his brother Bobby to talk to him about what life will be like after graduating from high school. And he asked his brother to tell him about dating. Finally, Sam shared his plan for supported decision-making with his mom, dad, brother, and doctors, and he put a copy of it on his phone and in his bedroom. Sam can change his plan any time he wants to, but his family all agreed to look at it at least twice a year, on his birthday and his brother's birthday, to see if there were things he wanted to change. If you want to see Sam's plan, go to the website and click on Sam's Plan, www.rethinkingguardianshipnc.org/Sam's Plan. If you want to learn more, contact Rethinking Guardianship NC at email.unc.edu. Thank you.
All right, and then here is just our website. Again, it's rethinkingguardianshipnc.org. And here you can see that we've we've got some information about the guardianship. We links straight to Statute 35A. We also include the relevant forms, so motion and the cause, the petition for adjudication of incompetence, notice of hearing, and appointing the guardian ad litem. And then here is our LRA hub. And so these are our fact sheets, the 19 fact sheets. And so here, we've got them organized by general. So again, assistive and adaptive technologies were specifically referenced in the LRA definition. And so we've got a fact sheet about that. And let's see, that's going to look good. And so we've made it a point to really try to write this in accessible language, so that, you with your child can review these documents together. Our website, we do have this toggle to where we can toggle between English and Spanish. Mind you, it's a Google Translate, so it's, limited by that, of course. But we do have that ability on our website to do that as well. Yeah, and then, the ABLE, Living Trust, Representative Payee, Special Needs Trust. We've got all of these that, we consider to be less restrictive alternatives. Yeah, okay. And so here are some resources. Again, we've got our Rethinking Guardianship website on there. Um, Also, just the Missouri Guardianship website has some really great kind of resources on their website. They've got this stoplight tool that kind of makes you think about the different areas and facets where some might need help. So when you're thinking about maybe a limited guardianship would be more appropriate, just kind of going through and seeing where less restrictive alternatives would be helpful. We also provide links to the National Guardianship Association's the standard of practice and the ethical principles that we went over earlier. So yeah, and then here is my contact information. So if you have any questions, feel free to email me. It's melissa.black@unc.edu. And then I'm going to stop sharing so you guys can see my face. So thank you. Right at 8 o'clock. That's perfect.
Perfect timing. Thank you so much. Okay, great. So we do have some questions in the Q&A, and I know we got some questions in the chat too, and I think we had someone say they couldn't see the Q&A, so they put questions in the chat. So we are going to go ahead and do Q&A first, and then go through the chat. Okay, so first question is, why is it so difficult to book basic appointments for my 19-year-old daughter with autism, given that we've chosen to support her autonomy without legal guardianship? And is it normal for parents of neurotypical adults to be shut out of scheduling this way too?
So are we talking, I'm assuming about like health appointments?
I'm assuming yes. Laura, you can, in the chat, you can comment and say yes or no, but I guess you're talking about health appointments, doctor's appointments, and things like that.
Yeah, so I mean, I think obviously, like a less restrictive, like I mean, I think there are certain like medical forms that you can get on file. So making sure you've got that HIPAA release form to where you can have those, conversations with the providers. With that HIPAA release form, you should also be able to make appointments and have access to the electronic health record. Um, if you wanted to also be named as a healthcare power of attorney, that's also an option. But yes, I just know that, when my kiddo turned 13, he had to, consent about 5 times before it was finally like uploaded into the electronic health record. So just because it happens one time, just sometimes the getting that information conveyed to all the different pieces and parts of a health system can be really frustrating, and I acknowledge that.
And it's funny because different healthcare providers handle things differently. I walked right into my daughter's eye doctor the other day without her, and she's 20, and I made an appointment for her. And I didn't think they were going to let me do that. But then like her other providers wouldn't let me do that until I signed a consent form or a HIPAA release or a HIPAA waiver. It's the same thing. It's called different things. That document does not give you like the right to make decisions.
Right.
And if you did get like medical or healthcare power of attorney, or I think it's also called a healthcare proxy. Is that right, Melissa? That same thing. Those things would only come into play like if your child couldn't make decisions
right.
or
Lack the capacity. Right.
Yes. I hope that answers your question, Laura. So you could ask the practice for a consent form or a HIPAA release form that your child would sign to give you permission to do things like make appointments. Okay. Will there be a certificate of attendance? Sure. I will make sure that a certificate of attendance goes out in the follow-up email. Thank you for that reminder. And let's see. Let's answer that one. Okay. What are those less restrictive alternatives? And that was asked a little over 10 minutes ago. So maybe that would have been before, but I don't know if you want to just.
Yeah, and I'm happy to go ahead and can I chat? I can chat. I'm gonna go ahead and just put in the kind of direct link to the hub. But we consider the the less restrictive alternatives to be assistive technology, supported decision making, healthcare power of attorney, even for like psychiatric advanced directives, if someone, stops taking their medication and they start kind of decompensating in that method, in that way, that, having that psychiatric advanced directive to where if they're not able to make those decisions and then you can kind of utilize that. able accounts, there's just, different, the like representative payee, we consider those to kind of be those less restrictive alternatives.
And those are all explained in the Rethinking
They
Guardianship
are. Yeah.
website as well.
Yeah.
It's a good resource. I launched a quick evaluation poll. I just wanted to do it before I forget because I am getting older and I do forget these things.
Totally.
So ECAC is largely funded by grants, and our grantees would like us to get some feedback on the activities we do. So if you just take a few minutes, I think it has like 3 or 4 multiple choice questions on it. We would appreciate it so much because we want to be able to continue supporting families at no cost. Let's see. So next question is, what if the person is competent and can make decisions, but refuses to make decisions for themselves? For example, fully capable adult that can work and manage their own finances, but absolutely refuses to do any such thing.
Okay. Well, I mean, I think, yeah. That's tough. I mean, I think maybe working with others in the supported decision-making plan, everyone kind of coming up with a role and responsibility to kind of help them make those decisions. Um, but yeah, that's a really hard one. I don't really have a good answer to that, I'm afraid.
Yeah, and that absolutely, and it's funny because we're dealing with this situation not on my child. My child is
Right.
15. She has autism. We're not dealing with it on that side. We are actually dealing with it on the other side of things where parents are getting older and are not making any decisions or bad decisions. And then it's like, is guardianship appropriate? So yes, it is
Right.
very difficult to kind of
Yeah,
navigate.
and I mean sometimes, not making a decision is a decision if they have the ability and the right to make that at the end of the day, which it might not be the best and the best decision for them, but it's still their decision to make, unfortunately.
Okay, next question is, if guardianship is granted for an individual and something happens to the guardian, such as death, what happens with that adult that is under guardianship? Can there be a next in line for guardianship?
So yeah, I mean that is something that the courts would then have to process, and make sure that the new guardian is named, and hopefully families have had those conversations as to who the next guardian should be. We discourage a whole bunch of people having co-guardianship because that means that everybody has a say in decisions, and that can be really difficult. So we don't ever really say that should be the option. But yeah, I mean, there should be kind of a plan already put in place, and then the courts having to then name that person as the guardian.
Okay, thank you. Next question. I don't know if my child is already of age and she does not think she needs guardianship, but is not capable of taking care of herself, medically decisions, financial decisions. She is 22.
Mm-hmm.
So I guess, Jennifer, is your question, she does not think she needs guardianship. Okay. But you don't think she's capable of taking care of herself. So and I'll let Melissa, she's the expert over me for sure, but you know, I don't know if you've tried like putting in like maybe a formal supported decision-making plan, and kind of involving her in it and kind of holding her accountable to those things. Healthcare, financial power of attorney. And, Melissa, what did they say? If bad decisions don't mean guardianship, is that
Right. Right.
right?
Yeah.
And I guess it depends how bad the decisions can get. And apparently they can get pretty bad, from what we're experiencing on the other end of life here. But yeah,
And
that's
I
complicated. I don't know if you have any
and I also
comments.
want to like just also note that bad decisions can be made in guardianship, right? Like, I mean, just there's still a person and they're still going to do things, and then yes, the guardianship can say, yes or no, but unless you're watching them 24/7, right? Like bad things can still happen under guardianship. It's not a force field to protect folks from everything. So bad things can still happen in guardianship.
Yeah. Okay. Medical or done. Yes. Okay. Can you provide attorney referrals that can help us with general guardianship process for our 17-year-old daughter who is nonverbal with severe neurological diagnosis? We live in Mecklenburg County.
I cannot, but I don't know. Yeah, I can't do that. But I know like family law, and then, obviously elder law, but that's not really the most appropriate here. But like family law would be probably your best avenue to pursue.
And also, Jenny, we're not allowed to recommend or rank any kind of provider either. But there is the Special Needs Alliance website that you can utilize to find attorneys in your area. So I can send a link to that in the follow-up email. Let me write that down over here so I don't forget. Special Needs Alliance. And then also, so the on the, what is it, Melissa? The North Carolina Department of Justice, why can't I think of it?
Yeah.
Website, the actual
Yep.
website, really, I feel does a good job of explaining the process, linking the forms, and saying exactly what's going to happen and how it happens. So we can send a direct link to that too. And you don't really need an attorney
Right.
in most cases for guardianship, right, Melissa?
Right. No, you don't. You do not. The form is pretty straightforward. And yeah, and then you file it, and then the sheriff will serve the notice of rights and the petition, and then the hearing. And then of course the person that's being considered for guardianship can always hire their own attorney, because again, that dual almost conflict of interest role of the guardian ad litem. So if they wanted somebody to just kind of represent their interests and only their interests, then, they could hire their own attorney.
Technically, yes. And the cost for that to file for guardianship is what, like 100 and something, 120, $150, something
I
like
think so,
that.
yeah.
Yeah. Okay, next question. How would a family proceed to move from complete guardianship to less restrictive options?
So that would be a motion in the cause. And so that's that form that I talked about. And so it's a motion in cause to modify the guardianship. So you can go from full guardianship to maybe a limited guardianship. And so that's, a really great vehicle to eventually, maybe fully restore rights. It's just kind of like, putting some guardrails on as you're kind of taking away the full guardianship status. So yeah, motion in the cause.
Yes. And also, I just want to mention a lot of these forms are also on ECAC's website, and a lot of Rethinking Guardianship stuff is also on ECAC's website under tools and information, under guardianship and alternatives. Okay, so we just answered that one. We are working on literacy, reading, spelling, math impairments. However, listening comprehension and cognitive capacity is good. How do we protect them from someone taking advantage of them by having them sign something they don't understand or can't read? Also, how would we help them with voting? Those are good questions.
Oh, so I know that the Southeast ADA has some really great voting resources, and that they um, have the ability and the right to vote, and maybe obviously it's a shifting and changing landscape, but maybe an absentee ballot to where they can, sit and take the time to kind of like review that ballot. And if they wanted to, also then do their research on their own while completing the ballot. So they're not kind of feeling that pressure of being in the room and having to, do the dots and then like, all of
People
that.
waiting for you. Yeah.
Right, yeah. So maybe
Yeah.
like an absentee or a mail-in ballot might be more appropriate in that scenario. In terms of, afraid of folks, taking advantage by, signature, that might be one of those things where like in a supported decision-making plan that you kind of both agree that if you have to make a decision that requires a signature, that we have, somebody else review that before we do that. And then on the extreme, if you're worried about like bank accounts being opened or something like that, then, maybe monitoring credit, setting up a credit, monitoring system to where you also get those emails if something is happening, in regards to that. Or, as a last resort, then maybe having kind of guardian of the estate to where they, can't do that.
Yeah, that's a very real fear for a lot of our
Mhm.
kids, them getting taken advantage of or conned into something or hey, sign here, you're an adult. And I mean,
I clicked on links
15,
I shouldn't
yeah.
have.
Yeah,
Right.
yeah. Oh, yes. Yeah. If
Right.
anybody remembers with the whole music CD, you get 20
Right.
CDs for a penny, and I signed my life away at 15, and they all
Right.
kept coming. They're like, now we need all this money. And my parents were like, what did you do? I'm like, oh.
Mhm.
But yes, no, my daughter who has autism is 15, but I do have a 20-year-old who is typical. And even her,
Mhm.
I have told her, I get to see everything you sign before you sign it. I have
Mhm.
already told her, and I said, it's not because I don't trust you. It's because I want to make sure that you're protected and I want to go over things with you and help teach you what to look for
Mhm.
and what things you should question, like and what legitimate things are. So yeah, that is difficult. And that was a wonderful question. Um, what was the name of the website that you just mentioned with step-by-step instructions for guardianship? Melissa put it in the chat, and it is nccourts.gov. We will also include that link in the follow-up email because I refer to it often. I
Mhm.
really think they did a great job.
Fantastic.
Yeah, about laying it all out and explaining it. And
Mhm.
they talk about alternatives in there. Also, they link the documents. They're like, here's the petition. It's in different languages. So I think they did a really good job with that.
Mhm.
Doesn't the state supply a guardian ad litem to help the person needing the guardian to get the best possible guardian?
So yes, I mean the court does, when you file for that petition, the court does automatically appoint the guardian ad litem. Um, and yes, they during that the notice of rights, they get to kind of have a say, like their preference as to who they would want to serve as the guardian. So yes, the guardian ad litem is listening to that and taking those notes and making that recommendation to the court.
Poor Jennifer, I am not sure why you can't see anything in the chat. Oh no. We will send everything in a follow-up email. Hopefully, hopefully you can see that. Technical issues are fantastic.
Oh, well, you know what? No, you know what? Because I sent it to hosts and panelists. That's on me. I did it wrong. I'm not
Melissa did it
used to
wrong. Let me
I'm
see.
not used to doing
Aha.
everyone. There we go. Let me do it now. There we
Oh,
go. Thank
Jennifer Heather
you.
said she can't see it either. So that Jennifer, I'm
Sorry
glad
about
you said
that.
something.
Ah,
It wasn't you.
I'm this is my first time on this like fancy like panelist type of Zoom, so like clearly I am still learning things.
And the rethinking guardianship. Okay,
Yeah.
perfect. Okay.
Perfect. Sorry about that
Let's
all.
see. Next question. How does the process work when parents are divorced and both parents want guardianship? I told you this was going to come
Mhm.
up. Yeah.
Sure. So I mean, yeah, we, at the North Carolina Guardianship Association conference last year, we had a clerk of court share that, parents were kind of spilling in their own feelings about things into guardianship proceedings. And basically, he just pulled them aside and was like, you need to mediate this and figure this out, or I'm going to make the decision for you. And what decision I make is the decision that goes. So
Mm-hmm.
really, it's just in the best interest to kind of put aside all of the other stuff and just kind of focus on what's best for the person that is the subject, potentially under subject of guardianship. But yeah, at the end of the day, the clerk of court is going to kind of see through all of the stuff and see through see through what's happening. And again, those attorney fees, if people are being really egregious with like constantly petitioning and trying to change things and trying to do stuff, then, they can start hitting them with fees as well. So kind of, looking to protect and preserve that.
Mm-hmm. Okay, next question. How long does the process usually take? Our son is 17 and we need to determine which option is best to support him.
I mean, I think it varies by,
They're
county,
in
right?
Wake.
Other in Wake. Well, I'm not 100% certain how long, it's the current process is taking, but yes, I mean, I think they recommend that if you were to start, considering guardianship to do so at 17 and a half. So you've got like that 6 month kind of cushion before they turn 18 and technically an adult at that point. So I think that's why the recommendation is, 17 and a half.
Let's see. Can you talk about guardianship of the person and guardianship of the estate? And can someone not have a guardianship of the person, but have a guardianship of the estate?
Yeah, so yeah, guardianship of the estate is just, managing the finances. In that instance, in that case, like, they have to file accounting reports with the court. Typically those individuals have to be bonded to kind of protect the assets. So yeah, it's a little bit more there's a different, like, definitely a different what's the word I want to use? um, different layer of kind of reporting and accountability when it comes to guardianship of the estate.
My son, who is 16 and has medical issues as well as severe anxiety, has expressed that he knows that he can't make medical decisions on his own. He
Mhm.
wants me to have guardianship over him. How is it handled if he doesn't contest it?
Well, I mean, I think that the guardian ad litem will still make their recommendation. So if they feel like the person has capacity and shouldn't be placed under guardianship, I mean, again, guardianship is always a last resort. And so it's not, I don't think it's anything that, the clerks of court in North Carolina really just say, take lightly. It's a very serious decision to place somebody under guardianship. So it might be one of those things where, um, yeah, I mean, if they need help making the medical decisions and you guys do it in consultation, and you kind of share what you think should be done, and they can say, okay, we've talked about it and we made this decision, then that's appropriate.
Okay, thank you. Wouldn't power of attorney be better than a guardian of the estate? Pros, cons, or advice?
Oh, well, that one I would talk to a lawyer about.
Yeah, and it's going to
Um,
depend on the situation too.
yeah, it
The
definitely will
fine
depend.
details.
Right. And again, it's that whole, like, the power of attorney doesn't kick in until that person doesn't have capacity anymore. So, whereas if you've been placed under guardianship, it's already assumed that you don't have the capacity. So, that's when you get to make those decisions. So, yeah.
And there is one more question in the chat.
Hmm.
My son just became 16. When we prepare for guardianship, should we should
Yeah.
we able to show our efforts of LRA? Should we be
Yeah.
able to probably show? Yes.
Yes. Yeah. So it's in the new form that box 6 is we tried the following less restrictive alternatives, whether it was supported decision making, whether it was representative payee, whether it was assistive technology. And then you just have to then in the next box explain, and these are the reasons why they didn't work and why the person needs to be placed under guardianship. So yes, the onus is on you, you as the petitioner to show what you've tried and why it didn't work.
All right, I'm going back through the chat just to see if it's hard. Hold on. Sorry, and it's jumping around. Next in line. We answered that one. Next in line for guardianship. Oh, I think we got a couple more questions in here. I think financial power of attorney can be used even when the person still has capacity. Right. Or only goes into effect when
Right.
the person loses capacity. That power of attorney. Yes, that's
Yeah.
that's true. I think financial power of attorney, you can make the choice. We're going through that right now.
Mhm.
Just the other end of the spectrum. So from our experience, both powers of attorney have only been when the person cannot make a decision. We have complete guardianship of our 25-year-old. I keep hearing you speak of reporting that may be
Mhm.
required. How do we know what is required as a family?
Um, well, I mean, obviously there'll be you'll know if you have to file a status report. And then obviously as personal guardians, you don't have to. It's only if the clerk decides that they need that status report. And that's just kind of new, and some clerks are really just kind of beginning to use that if they suspect that maybe the guardians aren't doing the best job in providing care. And it's just kind of like a guardrail just to make sure that they're doing what they're supposed to be doing. But yes, for the guardians of the person, um, you don't you don't have to file those reports unless it's specifically requested, unless you're a, corporate guardian or like a DSS.
Mm-hmm. So how would that be requested? I'm wondering. Like, would it come to, would they email you? Would they call you? They send you a letter in the mail? Like, how do
I think
they
it probably would be a letter in the mail, I
let
would
of the
think. Yeah.
mail?
Yeah.
Okay, great. As long as your son or daughter consents to allowing you in medical appointments and needing support in decision making, healthcare providers or any other authority cannot overrule that, correct?
Say it again. I'm sorry.
I guess she's saying as long as your child consents to allowing you into medical appointments and
Hmm.
needing support and supported decision making, healthcare providers cannot overrule that. So I think what she's saying, like if your kid is like, yes, I want my mom in here to, be in here with my appointment and support me in my decision making, the doctor can't say, sorry, no, it's going to be you.
Right.
Um,
Yeah, I would think so, yes. And but that being said, yes.
and I was navigating things in the chat. You may have said this and I may have missed it, and I apologize if you said this, but like supported decision making agreements and what you do with them once they're
Hmm.
made.
Hmm.
Um, and did you cover this? I'm sorry if I'm like being redundant.
No, no, no. Go ahead.
But you can share those with your child's healthcare providers and they can have them on file so they know about these things, and that's the wish,
Hmm. Absolutely.
and even bring a copy with you. I don't see why you wouldn't, right? To
Hmm.
every appointment, just in case you need to be like, here you go, this
Yeah.
is what we've agreed upon.
And I will say
um
North Carolina was very intentional about when they updated the guardianship law. So like some states have very formalized supported decision making agreements to where it is like specified, like, Jane will do XYZ, Bob will do that, right? And North Carolina said, oh, we don't want that because then it just feels like another layer of burden that you have to make it so like prescriptive. And so in North Carolina, it's great. They're like, you get to decide how you want to utilize this LRA. You can make it formal, you can write it down and everyone sign it, or you can just kind of make it informal. So I think that's really great that North Carolina, allows us to kind of have that ability to make those, to make it as formal or informal as we want it.
mhm. Okay, we have a question in the chat. Do you
Mhm.
have to try LRAs or less restrictive alternatives if the person has severe cognitive deficits?
You do. But again, it's, it would be probably very easy to explain why those LRAs didn't work. So. But yes, you
Mhm.
still have to fill out those two boxes.
And it gives you, if I remember correctly, yeah, there's the two boxes. You probably showed them, and I was busy in the
Mhm.
chat,
Nope,
right?
you're fine. You're
You
fine.
show the picture of the
Thank you
form.
for managing the chat.
Yeah. That where you just, I mean, you would put just that, right?
Yeah.
That they have severe
Right.
cognitive, and you could even
Hmm.
maybe put IQ in there or whatever, just
Right.
explain why, that wouldn't work. Because I
Right.
guess the whole point here is that it's not guardianship or nothing. There's a
Right.
whole spectrum of alternatives. Rethinking Guardianship is an excellent resource to explore those. If you have questions, and Melissa, I don't know if you shared your email address on your
I did,
slides
but I
or
can do it
not. Okay,
again. Yeah.
perfect. So we can share Melissa's email address again. You can always ask her. You can ask me. I will probably ask Melissa, but
Mhm.
and also for folks who may need support in Spanish regarding guardianship and alternatives. My colleague Millie Ramos, she works with me at ECAC, and she can provide support and assistance to people who would prefer to communicate in Spanish. And her email address is mramos@ecacmail.org. I will put it in the chat. I can't talk and type at the same time as I get older, so I need to do one or the other. Okay, one more question is, starting at what age do we need to have a consent form from our child to have full access to medical records and be able to schedule medical appointments for them, since they are not able to make those decisions yet?
I mean, I personally experienced it at like 12.
They,
Which
yeah,
was which was the most frustrating thing because I was like, I'm making the appointment, but I can't see when the appointment is to like copy it into my calendar because you haven't given me that access. Or you can't see the test results, or yeah. So I mean, I want to say it was like 12 or 13 that he had to provide his consent that I could have access to that information.
yeah.
And then at like 18 and older is when you need the HIPAA release and the HIPAA,
yes.
all that stuff. So yeah.
And that's when she was 18. That's when I signed the HIPAA release form. And again, some providers required it and some were like, it's fine.
Sure.
We know you're her
Yeah.
mom. Like, and they
Right.
they didn't question it. How is this done at 12? So somebody else said my son's doctor gave us access once he turned 12.
Mhm.
Yeah, they start at like 12 and 13, right? They start
Yeah.
restricting. Yeah.
Mhm.
And I'm sure it has a name, and I'm sure I'm not thinking of it right now, but I will also include information on that in the follow-up email.
Yeah, I'm trying to Google that real fast. It's parental consent.
And that's also around the age where they start asking the parent who is with them at the appointment to leave the room so they can talk to them in private.
Mm-hmm.
It happened right around then as well. Now, I don't think you cannot waive that. I don't believe like they're going to talk to your child by themselves because that's a way for them to ensure that they're not being abused and, all that other stuff. So they don't, they want time alone with, which I understand, but I also prepared my child for that.
Mm-hmm.
Because I did not do that with my older one because I didn't know it was coming. And she
Sure,
was kind of
yeah.
like, whoa, wait, where are you going? What are they going to do? And so I explained it in the moment and that I was okay with it and that I was right outside the door. But to my younger one who has autism, like even before the appointment on the way there, I'm like, remember, they're going to talk to you. It's just to make sure that you're safe. And that they want the parent out of the room because sometimes in some cases parents abuse children and they want to make sure that your parents are not like, it was very upfront with why they were doing that. Due to my son's autism, they never make me leave, but they see him every 3 months and no level of cognitive impairment. Okay, so that's good to know, Heather. So with my daughter, they do make me leave the room, and maybe it is different depending on the child's cognitive ability or communication, level. I suppose maybe that would be an interesting question for language too. If there was some kind of language barrier and the parent needed, anyway, that's a different rabbit hole. But thanks for letting us know that, Heather. Okay, well, it is after 8:30. We have one more question in the Q&A. Let's see if we can squeeze it in. Thank you. Great about having the plan. Yes. Yep. So keep that supported decision-making agreement. I think that is the route that we are going to go. We're going to try that first, and then we're going to work our way up. So, and I will have lots of experience with all of the other things very shortly, but with parents. So that's the other thing, guys. Like, not only are we considering this for our children, as our parents age, we are also considering all of these things for our parents as well. So it's fun on both ends of life. I just want to thank our interpreters so much for joining us from Full Circle Interpretation. Thank you so much, Felipe and Flora. Excellent job as always. And I hope we did not speak too quickly. Thanks so much for joining us. Again, I will send a follow-up email out. It'll probably be in about 2 days with a link to the recording, certificate of attendance, link to the Special Needs Alliance, the NC Court's website that lists out the guardianship process. Melissa, you mentioned Southeast ADA for voting resource.
Yeah.
So if you'll send me a link to that, I will send that out also. And then verbiage we can find around that 12-13 age range when they start restricting parents' access to things. And a lot of us are shocked by it.
Yeah, I'll send you. I was just kind of looking and there's some interesting stuff like on UNC School of Government about that. So
perfect. Send me that link. We will send it out. And also the recording will be on the ECAC YouTube long before we send out the email. So you can check out ECAC.org YouTube. All right, everyone. Thanks so much for joining us. Melissa, thank you so much.
Yeah,
excellent
absolutely.
Information. And we're going to do this
everyone.
again on Thursday at noon. So if you know of anybody that would benefit from this or would like to watch it live and have the opportunity to ask questions, please tell them to join us on Thursday at noon. Okay. Have a good night, everyone.
Thanks, everyone.